So the Supreme Court decided a really important tax case today. For the first time in over half a century, they decided a case based on how a trust should be taxed. North Carolina wanted to tax the entire amount in a trust just because one of the beneficiaries lived in North Carolina. This is North Carolina Revenue v. Kaestner. Why is this super important? Because states decide differently when they can tax a trust. Some of them do it just because you made the trust there. Minnesota's that way. If you made the trust in Minnesota, they want to tax it the whole time. Some of them do it based on the beneficiary. If the beneficiary, they were going to tax the whole thing, even if every beneficiary is not in North Carolina or in that state. Other states do this kind of mixture of things. Well, two cases have gone to the Supreme Court this year. One is Fielding, and that's going to examine Minnesota's rules about whether or not just having the settlor, the person who made it, be a resident means you can tax it forever. And then Kaestner went up because people want to do that based on the beneficiary. The justices got together after oral arguments and they decided that you cannot tax a trust solely because the beneficiary is a resident of your state. This was 9-0, unanimous. It really goes back to whether or not the trust itself has taken the advantage of any of the benefits, opportunities, and protections of the laws of that state. Has the state given anything to the trust that it has the right to deserve to be paid back for, to be compensated for, to expect payment from? And if the beneficiary is just the resident there, but they have no control, they can't demand the money, they don't possess the money, then that's not enough. This is a similar kind of analysis as if some court wanted to give you an order. You had to be in that state, you have to have contact with that state, get the protection of that state for them to be able to even get jurisdiction over you. It's the same kind of analysis here. The court flat out said that we have to look at the constituent person of the trust, whether it's the trustee, whether it's the beneficiary or the settlor, whichever one's the resident. Did they do something that takes the benefits and the protections of that state to such a degree that the state can afford to ask them to pay them back, that it can be expected, that it's right? Key things to take away from this. The Supreme Court said just because the beneficiary is there, they can't. And it's forth of a discretionary trust, meaning that the trustee never had to give them any money. It was in their sole and absolute discretion not to give any money out. It's a different analysis if they're entitled to half of it at 25, half of it at 40, and things like that. If you're able to demand it, then maybe you have some control of it. Maybe we should say you possess it, and then maybe the state could tax it. But if it's purely discretionary and they have no right to it until we give them the money, then you can't tax just based on there being a beneficiary. That's very important. And there's a lot of people out there that are still writing those trusts that say, hey, at 25, give them this or that. Let them demand it, let them do that. It might not be their best way to go now, because you could be opening up that beneficiary, if they move to another state, to pay that state taxes on the trust income, whether they got it or not. You could open that whole trust to be taxed, depending. Now, taking that aside, they also were very careful to say this decision should only be interpreted along these lines for reasoning, and that the beneficiary alone is not the sole factor. They specifically said we're not going to talk about it where the beneficiary is just one factor among several. And we're not going to make a decision about whether or not it's just the settlor. That was a key. They were saying, don't read this into that Minnesota case that's coming up here. We're not saying how we were going to decide on that one. That one we're still considering. We might weigh in, we might not. I'm starting to think that the Supreme Court will actually hear Fielding and kind of go along these lines. And it gives us an idea of how they're going to reason and look to this. They're going to look and see if the settlor being in Minnesota for the initial phases, creating that trust, giving them protection, perhaps giving the trust protection that time, if that's enough, even when the settlor's dead, to maintain that connection forever. It's my opinion they won't go that it goes forever. They're going to have to come up with some kind of line to draw in the sand, because just because you live in one state 100 years ago, 200 years ago, does that really mean that that state should be able to tax everything forever? I don't think we'll get to that point, but that was still reserved. I still think they're going to hear Fielding, and we still have to wait and see where they're going to go with that. But it's good news. is going to show that if you don't get possession and control through giving anything but full discretion to the trustee, then you actually might be cutting off the right to tax. So not only is it better for asset protection, better for the dynasty and the legacy of the trust, but it's also going to be better for taxes to do that. We really shouldn't be doing too many trusts that aren't fully discretionary now when we're dealing with large sums of money and dealing with tax consequences down the future. It also keeps it out of the out of the estate of the beneficiary, so it doesn't have a chance to get taxed again. Now the big question is, what about the settlor? We know that the trustee just being outside the state means you can't tax just based on the trustee. We know that the beneficiary being outside doesn't mean you can just tax that. I believe the Supreme Court is going to decide that just because the resident is in the trust maker is a resident doesn't mean that you'll be able to tax that trust forever. Probably for a while, especially initially if you make it during your lifetime, because your assets are going to be in there and you're going to benefit and you may even have kind of control over them. But forever, I don't think that reasoning will kind of line up. If they decide that way, then if you have a purely discretionary trust and you set that trust in a state, whether it's Nevada, South Dakota, one of those states that doesn't have a fiduciary income tax, then we won't have any state level taxation on the money while it's inside the trust. That can save you a lot of money and really let it grow. And then we just worry about it when it comes out to the beneficiaries if the states are going to tax it at all. And it probably won't if it's principal that rolled over from the next year. Just that income in that first year is probably where it's going to end up going. So this is great news for the taxpayer. Start thinking about those planning decisions. Probably should be citing against any trust that isn't purely discretionary from here on out. And be ready, because if the fielding is decided against the state, depending on the new criteria that Minnesota and other people come up with, there may be a great opportunity to put a trust in South Dakota, Nevada, one place like that, and really do some tax arbitrage, really save some asset protection and other things, and get great outcomes for legacy wealth.